How long do you have to file a claim after an accident? The answer is as soon as possible. So let's get into it. While Louisiana law may say that, for example, if you're in a motor vehicle accident, you have a year to file a lawsuit, the nature of the claims process and the evidence that you need to make a claim militates towards always immediately making a claim and collecting the information which supports your injury claim. Let me give you a hypothetical. If you're in a car accident in New Orleans and you are wondering, should I call the police? Should I begin to take photographs? Should I get a police report? The answer is always yes. Let's walk through each piece of evidence. Photos to begin with. You need photos to support a claim, and you should take as many of them as possible. You also want to submit them to an insurance company and or a law firm that you hire to represent you, because you want somebody to store those photos, make sure they have them organized, they keep a custodian record of them, and so those photos are never lost. Technically, they may be in the cloud if they're on your phone, but if you lose the phone, if they don't upload to the cloud, if you lose those photos, you potentially lose a key piece of evidence. And on that point, a key piece of evidence, we next go to witnesses. Witnesses are critical pieces of any personal injury claim, whether it's an MVA, a slip and fall, an offshore incident, etc. And witnesses have a tendency to A, disappear, B, decide they don't want to cooperate later on as their life progresses and they're focused on other things, or C, sometimes witnesses pass away. We're all going to die. Spoiler alert, we're all going to die. And so the sooner you have witness statements and witness contact information, their phone number, their backup phone number, their email, their address, for your law firm or you to contact them, to take their sworn statement, to record that in case something happens to them, they move out of state. We can no longer compel them to come back if you go to trial in your car accident case, because we can't subpoena and force out-of-state witnesses to appear here. Now, if we knew where they went out of state, we could always fly there, depose them, and offer their deposition in lieu of live testimony, which also is not as strong in a jury trial. The jury wants to see the witnesses. They want to judge their credibility. They want to hear their testimony. So besides just photos, we're talking about witnesses, another key piece of evidence which goes stale the week or 2 weeks or 2 months after a claim happens. And so you want to immediately make a claim because you want to preserve that witness testimony. Police reports. Should you wait for the police report? Yes, you want to immediately stay out there because you have another person who is documenting what happened, documenting who the insurers are, getting more information together and gathering an official document, which may not be admissible because police reports are technically hearsay if the police officer is not an accident reconstructionist and didn't witness the collision. So if the police officer didn't witness the collision and he or she just comes after and documents what both parties say, that is kind of classic hearsay under Louisiana evidence code. But if that cop didn't see what happened but is a qualified accident reconstruction expert, that cop could say, hey, based on what both those drivers told me, looking at the scene, in my experience as an expert accident reconstructionist, I could testify that the other driver was at fault, which could potentially help your claim. The cop also may have coincidentally seen it, so that cop becomes a potential witness as well. So all three of these pieces of immediate evidence, the photographs, the police report, witness testimony, is critical. And we've skipped over a very important one besides exterior witnesses. Your memory, the other driver's memory, it all fades. Okay, we all don't remember things. I don't remember what I had for lunch 2 weeks ago. So you begin to lose your memory of certain aspects of what happened. And while you may remember an acute and specific event like this more than what you had for lunch 2 weeks ago, longer, key pieces of things that happened, what you saw, that kind of erodes over time. And so you want to give statements. You want to document what happened. You want to tell your attorneys that you hire exactly what happened in the collision, what time of day it was, what was the weather like, what did you see right before, what did this person do, how fast was that car going, what did you see to the behind you. All of those facts support your claim, support the version of how the incident happened, and so the party's own testimony becomes stale and different. So while technically under Louisiana law, you may have a year or two in a motor vehicle collision, depending upon when your collision occurred. The legislature just amended our statutes of limitation, which we call prescriptive periods here in Louisiana under Louisiana law, to where if you're now, as we're shooting this in the end of 2025, if you're in a collision now, you have 2 years prior incidents that occurred before this law changed only had 1 year. So it's a mixed bag. Some MVAs have 1 year, some MVAs have 2 years in Louisiana right now as we're filming this. To file suit, making the claim and collecting all the information and documenting what happened to support your claim is much different than what the legal requirement is for when you can file it. The answer is you should make the claim immediately. You should begin documenting everything immediately. The other side of that, besides just collecting all your documentary evidence, photos, police report, witnesses, your testimony, is your medical causation and your injuries. So if you get in a car accident and you are in pain and you're hurting and you don't go see the doctor for 2, 3, or 4 months because you just decide you're going to tough it out, and I've grown up with a lot of people in South Louisiana who would be fit that character profile, say, I'm just going to tough it out and avoid going to the doctor. What's going to happen is you're going to imperil the ability of you to meet your burden of proof at trial and establish what's called medical causation, causally relating your injuries to this collision. And so once again, if you're in pain, you should immediately go see a doctor, and that's another piece of evidence which is key in your claim because you want to document exactly what injuries occurred in connectivity with this collision or this incident. No medical doctor, whether it's an orthopedic surgeon, a neurosurgeon, an MD, a chiropractor, physical therapist, none of them are going to feel very comfortable saying, yes, more likely than not, John Smith's injuries are caused by this collision. If you have the collision on this day and you don't see anybody for 4 months, it becomes difficult for them to make that argument to medically connect those injuries, even though they believe you. And even though you're telling the truth that, hey, I got hit and I was immediately feeling my back and my neck hurting me, I just didn't go see anybody for 4 or 5 months. It's going to be hard for them to make that argument and to be believed by a trier of fact because there was such a large gap between the incident when you went and seek medical treatment. So it is one of those things where if you're hurting, you need to go see a doctor. You need to go see a professional who documents it and also tries to get you better and gives you some recommendations, not only whether it is they perform cupping, dry needling, scraping on you, any type of electromagnetic treatment where they're using a machine to kind of loosen up those muscles and or joints that were injured. Even if they're not just necessarily doing those types of things, they're making those recommendations for home therapy and they're documenting those injuries. They're documenting what happened in the incident to connect those injuries to the incident and make that medical causation chain a bit easier. So the short answer is as soon as possible. While there are legal requirements that you may be able to file suit in 1-2 years after the collision, you should immediately begin working on your claim and documenting all this, and you should immediately begin consulting with an attorney. The insurance company does not have your best interest at heart. I'm not saying insurance companies are inherently evil. They're not. But they're there to protect their interests and their shareholders and their profitability. You should be seeking professional help to protect your interests, your well-being, your betterment, to ensure that you get better and you're protected. You have somebody representing you solely on your behalf in discussions and in coordination with the insurance company. And luckily, in what we do, that's for free at the beginning. So if you have an incident in Louisiana, whether it be a car accident, offshore incident, slip and fall, please give us a call. You can receive a free consultation. We'd love to provide that to you at Scott Vicknair Injury Lawyers, and we can talk through all these pieces of your case as soon as possible. Please give us a call today. We'd love to talk to you and or your family and help you get better today. I'm David Vicknair with Scott Vicknair Injury Lawyers. You've just been involved in an 18-wheeler accident. Is it the same as an accident with just another vehicle?